to identify the people that are on the platform. And a reminder again, the session is going to be live streamed on various social media platforms. And also the session will be recorded live, recorded for later broadcast on Parliament TV, which is found on DSTV channel 408. We request all the distinguished participants on the platform to please ensure that every time they take to the floor, they have their videos on in order to enable us to do a proper broadcast of the session, and also for posterity and safekeeping of the contributions of all the participants that are on the platform. Also, we request you to switch on a video so that we are able to, from time to time, take pictures that we can use on our various social media platforms, and also later publications that are going to be done in relation to the session today. We would appreciate your assistance in that regard very much. I see there are still more people that are logging in. We will give them another 5 minutes before we start. Apologies for the delay. Maybe while we wait, can I request all the distinguished participants who are on the platform to please switch on their videos so that we are able to establish if they are properly framed for the session. So that we do the normal logistics as well. Cameras on, please. Thank you very much. Can I request that we please follow the following in terms of placing our cameras and catchers? If you are using a mobile device, could you kindly use the vertical, the landscape side of the camera instead of the portrait? Instead of using this side, you follow it this way. You place it on a landscape so that we are able to fill the entirety of the screen. Because if you're using the portrait one, it sort of cuts the screen into half, and then we've got a black spot. And also, if possible, can we ensure that all the light sources in the room that you are participating from are in front of you instead of being behind you? Because if they are behind you, there's going to be a glare of light that is coming just behind you, and it's going to make it easier for us to be able to see you. Mr. Abdul Rahim Tajuddin, is it possible to switch off to close the curtains behind you, or maybe move around so that the light that's coming out from behind you is ahead of you, in front of you, sorry. I'm not sure, I can't hear you. You're still muted.
Sorry, I beg your pardon. I didn't get you on that.
I was saying that is it possible for you to move around so that the light that is from behind you is in front of you? If you turn around, yes.
Yes. Okay, I will do that. Yes.
Thank you very much. Also, can we follow the following naming convention on our platform, on our devices? I request the distinguished participants to please ensure that their devices are named in the following manner. You first start off with the country that you come from, and then followed by your name. Or you start off with the organization that you represent, and then followed by your name, so that it's easier for the facilitator and everyone on the platform to identify the countries that are represented. And We are still missing a few people on the platform. I said that we'll give them 5 minutes. It's 2 minutes left now before we can start. Maybe while we wait for them, can I do a roll call just to see which countries are represented on the platform? Do we have anyone from Angola? Mr. Vijay Apadu, were you trying to say something?
I'm from Mauritius. I'm from the Financial Crime Court, Financial Crime Division. I'm the president of the Intermediate Court of Mauritius.
Mauritius. Thank you very much, sir. Welcome to the session.
Thank
Could you kindly rename your device into?
Yes, I'm having some difficulty. I'm having some challenges to rename it. You see, I've tried, but unfortunately.
Let me see if my colleague can't help you. Ronald, would you be able to rename the platform, the device for us, please? Also, Mr. Abdul Rahim.
Yes. Can you hear me?
Yes, we can hear you. Thank you very much.
Yes. I'm from Mauritius as well. I work at the Intermediate Court Financial Crime Division together with Mr. Apadu, who is the president of the Financial Crime Division at the Intermediate Court.
Thank you very much, sir. I see we have Mauritius on the platform. I see also we have Malawi. Do we have anyone from Angola? Anyone from Botswana? The DRC? I don't see the DRC. Do we have Eswatini? Lesotho? From Lesotho, we have Madagascar. Do we have Madagascar? I see Malawi is here. Mauritius is here as well. Do we have Mozambique? Namibia? From Namibia, we go to the Seychelles. South Africa. Tanzania. Zambia. Zimbabwe. Looks like we're still missing a lot of people on the platform. Please bear with us while I ask my colleagues who are assisting in terms of the administrative parts of the invitation and stuff to reconfirm. I also see that our keynote speaker is also not on the platform yet, and also the facilitator. I don't see them on the platform yet.
The keynote speaker is joining Odyssey.
Thank you very much for that confirmation, Mr. Kurasha. Should we wait another 5 more minutes to facilitate that? process?
Let me just check with the facilitator, otherwise we must be starting, to be fair to those that are already on the platform.
Thank you. Distinguished participants, just a reminder again, the session is going to be conducted in the two SADC languages, which is English and French. I request everyone who's on the platform to please choose the language that will enable them to follow the proceedings sufficiently, and the interpretation icon can be found at the bottom of the screen. There's an interpretation icon there. If you're using a mobile device, there should be an icon that is written more. When you click on it, you should be able to get an interpretation icon, and then you choose the language of your choice. You can also mute the original language so that you can only hear the language that you are listening. You want to listen in on between English and French. And then also we request all the distinguished participants who are on the platform to please ensure that every time they take to the floor, their cameras are on so that we are able to see them. Also keep your microphones muted at all times until you are given an opportunity to speak. In order to get the attention of the facilitator to give you a platform to speak, there's a reactions icon at the bottom of the screen as well, where you can raise your hand. Once you've raised your hand, you'll be given an opportunity to speak. Those are the conventions that we request everyone on the platform to follow. And also in terms of the naming, we request all the distinguished participants to please ensure that they name their device starting off with the country that they come from, and then followed by the name of the participant, or else you start off with the name of the organization that you represent, and then followed by your name as well. Those are the conventions that we will follow. We are just waiting for a few more minutes in order for our facilitator and the keynote speaker to join the session. Then we'll be ready to start. Another reminder is that the session is going to be broadcast, live streamed actually on YouTube and other social media platforms. We request all the distinguished participants who are on the platform to please bear that in mind. And also it will be recorded for later broadcast on Panelman TV, which is found on PSTV channel 408. Yeah, that's about it in terms of the logistics. Please bear with us. We're just waiting for a few more minutes so that we can be able to. I see on the chat platform as well. Please use the chat platforms in terms of sending messages as well. If you are struggling to use the icons that are at the bottom, there's a chat platform where you can send messages there for the attention of the facilitator and our colleagues in the IT who will be able to help you solve those problems. I see someone from Madagascar is trying to log on, but is experiencing some network problems, but definitely join the meeting. Thank you very, very much for that. So we will have Madagascar, Malawi, Mauritius, and that have confirmed their participation. Do we still not have anyone from Angola? Botswana, just in case they joined after we did the roll call. DRC. Eswatini. Madagascar is joining. Malawi is here. Mauritius is here as well. Anyone from Mozambique? Namibia? And then we go to the Seychelles. South Africa. Tanzania. I think I saw my good friend Omari from Tanzania earlier on. Omari, do we have anyone joining from Tanzania? Oh, it seems like it's not on the platform again anymore. Anyone from Zimbabwe? Thank you very much. Let me now hand over to, in order to save time, hand over to the facilitator. Is Dr. Moyo here? So that we can start.
He's still trying to join Modise. So
Right.
you could either start the meeting or I could step in and start the meeting.
Please assist me with the stepping in, my good say.
Thank you very much, Modise, and our sincere apologies, distinguished participants. Let me recognize the Secretary General of the SADC Parliamentary Forum, recognize our keynote speaker, Justice Dingake, and representatives of Chief Justices, magistrates, and other judicial officers that service financial tribunals in member states. Distinguished participants, allow me to welcome you this morning to this consultative meeting on the SADC model law on public financial management. We are consulting with the Chief Justices, the magistrates, and other judicial officers that service financial tribunals from SADC member states. And this morning, to kickstart our program, my name is Shaunen Kurasha. I'm the program manager for democracy and governance at the SADC Parliamentary Forum. I'm stepping in for our facilitator, who's still trying to join the meeting, Dr. Gordon Moyo. As soon as he joins, I'll be handing over to him. At this juncture, allow me to invite Excellency, the Secretary General of the SADC Parliamentary Forum, Madam Boyemo Sehoma, to deliver a welcome remarks.
Thank you very much, Director of Ceremonies. Allow me to establish the protocol this morning. Our keynote speaker, Professor Dr. Oagile Ki Dingake, Judge of the Supreme and National Courts of Papua New Guinea and Judge of the Residual Special Court of Sierra Leone. Distinguished Chief Justices, Magistrates, and other judicial officers serving on financial tribunals from our SADC member states. Mr. Daniel Greenbeck, the legal drafter for the SADC model law on public financial management. Members of the technical working group of the SADC model on public financial management, the meeting facilitator and a member of the technical working group, Honorable Dr. Gordon Moyo, former member of parliament, former cabinet minister, and a lecturer at Lupani State University, Zimbabwe, and a member of the PFM model law. SADC citizens following proceedings on various platforms in our social media, staff of the SADC Parliamentary Forum, and staff from our national parliaments, members of the media, distinguished participants. Honorable justices, magistrates, and judicial officers, it is with immense honor and deference that I welcome you today to this August consultative meeting on the SADC model law on public financial management, hosted under the auspices of the SADC Parliamentary Forum. At the outset, I wish to highlight that the SADC Parliamentary Forum is proud of its partnership with the Southern Africa Chief Justices Forum, as well as the judicial officers existing across the SADC region. As you may be aware, the SADC Parliamentary Forum is accustomed to holding widespread consultations for its model laws under development, in view of ensuring that the model laws are responsive to the current needs and demands of the SADC citizenry. Distinguished participants, today, we thank you for making the time to attend this collaborative meeting, despite your busy schedule and various court duties that are before you. We equally express gratitude for your belief in good governance and public financial management, which is inherent to the stability of any democratic society. The SADC Parliamentary Forum has always paid tribute to the sacrosanct independence of the judiciary in SADC member states, which is not only a paper promise, but is actually actively implemented by chief justices and other members of the judiciary. This consistency of the judiciary has indeed gone a long way in consolidating the democratic drive in Southern Africa. Distinguished participants, as you may be aware, a number of stakeholder consultative sessions have been held already on this SADC model law on public financial management. The objective of the SADC Parliamentary Forum during consultations for every model law is to engage the three limbs of the state in view of garnering the whole picture of stakeholder views and opinions concerning the theme under consideration. For the SADC model law, I wish to underscore that this is the first consultation with members of the judiciary, which consists of chief justices, senior judicial officers, and magistrates. Your voices, or your voice, is thus important to the deliberations. And the SADC Parliamentary Forum firmly believes that although Parliament adopts laws, the judiciary is to have a say on their propriety for enforcement purposes. Distinguished participants, chief justices and magistrates and judicial officers are at the helm of the justice system. They are not investigators or prosecutors, but are independent emperors who sit independently to evaluate the evidence and the strength of the arguments regarding offenses related to public financial management. In this contemporary world, where financial crimes have become pernicious and sophisticated, and is often committed across jurisdictions, judicial officers have to deal with issues such as standard and burden of proof for money laundering, the appropriateness of sentences for public financial management related offenses, and furthermore, on issues of chains of custody, particularly when the evidence emanates from foreign countries. Distinguished participants, often financial crimes does not involve physical violence, and yet the economic violence that accompanies it is devastating and dire. So much so that entire countries can go bankrupt with a single financial crime. Ponzi schemes in the SADC region are recent examples of financial white-collar crimes committed by offenders who have mastered the nooks and crannies of fiscal systems that is constantly evolving. Distinguished participants, in the court environment, judicial officers thus have an onerous task at hand in enforcing financial crime and other public financial management irregularities. Judicial officers need to decipher the truth by evaluating documentary evidence, as well as assessing the demeanors and attitudes of witnesses who take the stand. With their vast experience and knowledge, judicial officers will thus have the best idea whether offense provisions of the model law are adequate and sufficient to meet the interests of society from a judicial perspective. Today, we expect that Chief Justices and magistrates and judicial officers present will consider the provisions of the model law as lawyers, and furthermore, take note of Part 11 concerning public financial management offenses, such as financial irregularities, maladministration, and financial crime. It should be underscored that not every financial crime has been addressed under the model law, since it was opined that a separate legislative instrument would be necessary to comprehensively cover all issues related to anti-money laundering, or CFT. The model law on public financial management, as the name indicates, is designed to deal with public financial management offenses, and thus only financial crimes which may have an impact on public financial management. It also goes without saying that issues such as burden of proof, prosecution policy, or admissibility of evidence will be covered already under domestic law and have not been included in the model law. In this respect, judicial officers and magistrates today are most welcome to advise on whether special provisions or admissibility of evidence need to be included in the model law, considering the cross-border nature of transactions and the difficulties in establishing an untainted chain of custody. Honorable Chief Justices, magistrates, and judicial officers, I wish to highlight that domestication is normally within the province of the executive, since it is the executive which takes the decision to bring the bill to Parliament. However, it is the SADC Parliamentary Forum's view that judges and judicial officers also have an inherent role to play in the domestication process. Indeed, judicial officers may assist in the uptake of the model law by liaising with the offices of the Attorney General to give their green light on judicial provisions in relation to which they are consulted upon. These are usually sentencing provisions and provisions that relate to the court system and offenses to be tried. In this respect, judicial officers may react on bills and laws when consulted upon for guidance by representatives of Attorney General's offices. I wish to end by saying that law and order with respect to public financial model law cannot be achieved in a single day. However, there is a need to start somewhere and to set the legal machinery into motion, particularly by engaging those who hold the gavel and send offenders to jail. Chief Justices, magistrates, judicial officers, you are essential. You are essential role players to eliminate malpractices relating to public financial management. Hence the engagement of yourselves today. You write judicial precedents which become binding on lower courts and can even overturn judgments. There is thus a need for public financial management to come into the judicial radar for further progress to be made on the model law and for domestication to be triggered at the appropriate time. The SADC Parliamentary Forum recognizes that democracy will continue to live and thrive as long as the judiciary lives and stands as an insurmountable rampart against threats of good governance. With these words, I thank you for your kind attention and wish you fruitful deliberations.
Thank you very much, SG, for those remarks. At this juncture, I've seen that the meeting facilitator, Dr. Moyo, is in the meeting. May I confirm if you are ready to take over, sir?
Sure, thank you.
I have the pleasure to hand over to you. I followed that you were in when the SG delivered the map.
Okay, thank you.
Okay.
Thank you very much. No excuses. I should have known that ICTs can be a nuisance. I should have known. So no excuses. But otherwise, thank you very much, Honorable Madam SG, for the opening remarks. To our colleagues here, the Chief Justices, the judicial officers, magistrates, and the entire legal fraternity, the legal minds that are here to engage on this model law on public financial management. We do recognize your presence, all of you, and we do value your presence. You are the central nervous system of what we are trying to do in this model law. So we will really appreciate that you have taken your time, as the SG has already alluded. For now, allow me to have the honor to introduce our guest speaker, a very esteemed member of the legal fraternity, Dr. Ojile Ange. Please forgive me my pronunciation. The brief CV that I have, it's very long. It's very long because the work has been done over the years. But I'll just summarize so that the colleagues who are here can appreciate the kind of work that has been done by our colleague who is here. Dange is one of the most celebrated judges. Actually, some people believe that he is the greatest judge in Botswana. Botswana has ever produced, whose services are now sought in many jurisdictions. He is currently a judge of the Supreme and National Courts of Papua New Guinea in the Pacific north of Australia. He is also a judge of the Residual Special Court of Sierra Leone, appointed by the Secretary General of the United Nations in 2013. Dange is armed with a PhD in law from the University of Cape Town, an LLM from the University of London, and the LLB from the University of Botswana. He has a number of postgraduate certificates in international development studies and political economy of development from the University of Oslo and London School of Economics. He has been recognized as an exceptional and distinguished scholar by a number of universities around the globe, including the University of Pretoria, Cape Town, James Cook University in Australia. The latter recently, in December 2018, appointed him adjunct professor of law. This is the second professorship in law that he has been conferred, on him by an international university after the conferment by the University of Cape Town. Dange is committed to sharing the extensive knowledge of the law with universities, communities working on rights, SRHR, gender, governance, among others. He is constantly engaging with students and staff in legal research in the areas of his expertise. This is the kind of a person that is going to deliver to us our opening, not opening, but our special speech for you. Over to you, Your Worship. Dr. Dange, Honorable Justice, thank you. Over to you.
Yes, I was saying, Dr. Moyo, Honorable Facilitator, you have been extremely kind and generous in the accolades you have showered upon my person. I thank you for so doing. Let me start by recognizing the presence of Her Excellency, Ms. Koma, Secretary General of SADC PF, my lords, ladyships, and your worships of the magisterial bench, Mr. Daniel Greenberg, the legal drafter for SADC Model Law on Public Finance Management, members of the Technical Working Committee for the SADC Model Law. I have already recognized you, Dr. Moyo, SADC citizens who are watching online from wherever you may be, members of the media, distinguished participants. Allow me, as tradition, because I'm addressing their lordships and ladyships and worships, to bow in respect to their presence and pay my respects to them. It is an honor like no other honor that I have been requested to deliver this keynote address to leading justices and jurists of our region on a matter as intricate as the legal aspects of public finance management. But before I delve into the substance of my speech, I wish from the very bottom of my heart to congratulate the Secretary General, SADC PF, and the staff at SADC PF for the pioneering work they have carried tirelessly and consistently on matters of model law. This is among many others that they have come up with in order to guide the region on the best approach to regulating certain critical areas that governs our lives. As the Secretary General often points out, the model law is some form of soft law. It is not necessarily binding on states, but it is a rich resource upon which member states can learn a lot, pick and choose what suits their circumstances in order to make the necessary legal framework that they need in their respective countries. Today we meet to be consulted on the SADC model law on public financial management. This aspect of the law is not one in which most of us deal with on a daily basis. Public finance deals with a set of laws, rules, processes, systems, and procedures that govern matters of public finance that sovereign nations or subnational governments often come up with in order to deliver certain key resources or goods and services to the nation state. Some amongst us may wonder quietly whether the courts have any meaningful role on public finance management, or whether this is not a matter in the exclusive preserve of the executive in keeping with the doctrine of separation of powers. The answer, of course, Director of Proceedings, is that in countries that subscribe to the rule of law, no aspect of human endeavor is immunized against judicial scrutiny. The SADC community is based on the rule of law. Consequently, neither of its members can avoid judicial review of any decision they take in exercise of public power. This, of course, includes matters of public finance. There is an increasing recognition in every member state that every exercise of public power must be justifiable. And while as countries differ on the extent to which courts can intervene in certain matters, including matters of public finance, including matters of public procurement of goods and services. It is now broadly accepted that the courts can intervene in order to ensure that the laws that are in place that govern matters of public finance are scrupulously adhered to. The doctrine of judicial review has a long history. Many amongst us here will remember that it is traceable perhaps to the famous case of Marbury versus Madison, decided in 1803 by Chief Justice Marshall in the United States of America. That case set in motion judicial review. It established that it is within the legitimate province of the courts to scrutinize legislation and, in actual fact, to declare any legislation that violates the Constitution to be unconstitutional or invalid to the extent of the inconsistency. So ever since that famous case, the Marbury versus Madison in 1803, the phenomenon of judicial review has grown so exponentially across our respective countries that today in almost every SADC state, courts of law are called upon to scrutinize legislation and ensure that there is compliance with legality, and that there is compliance with reasonableness, that there is compliance with rationality. And all these are necessary in a model law to deal with public finance management. The Secretary General has spoken eloquently about what that entails. The spectrum is very wide. You deal with financial crimes, you deal with issues of fraud, commercial fraud, money laundering, and all that. At the end of the day, whether that is established as a fact and as a matter of law is actually the province of the courts. On the whole, it seems to me that the explosion that I speak about was driven by, among other things, the increasing faith of our leaders and our people in the importance of a constitutional state that is run in accordance with the rule of law. It is that constitutional state that is run in accordance with the principles of the rule of law that the judiciary has a particular significant function to be the guardian of our laws, to be the guardian of our constitution, to police legality, and to ensure that everything is done in a manner that benefits the public, in a manner that is legal. Public finance management has the main goal of improving the well-being of a country's population. This is usually done through systematically monitoring decisions made by public authorities, as well as identifying emerging risks and developing measures and mechanisms to prevent them. Public finance management basically covers all elements of the budget process, such as budget planning, budget execution, accounting, reporting, internal controls, and auditing. The key actors in management of public finance include, among others, the executive, the Ministry of Finance, the legislature, of course, it passes necessary laws, accountants, auditors, lawyers, yes, and judicial officers. And as stated in the preceding statement I made, the main elements of public finance are government activities that relate on the main to a number of things that include collecting revenue. This involves tax collection, which in the main is the main source of income for governments, sales tax, income tax, estate tax, property tax, all forms of tax, duties and tariffs. So it is a very important area in which the judiciary must take interest, because the welfare of our nations depends on large measure in ensuring that public finances are marshaled in a manner in which the public would benefit. We need financial accountability, we need transparency, we need justice in ensuring that financial laws are complied with. Among many other things that sovereign states are concerned about across the world when we talk about public finance management or even legislation are issues of bribery, embezzlement, money laundering, fraud, extortion, abuse of power, conflict of interest, nepotism, collusion. Other issues such as not following the proper processes in the procurement of goods and services and ensuring that projects are carried out within allocated budget and timeframes are extremely important. So at the heart of any legislation that intends to benefit the people are the elementary principles of the rule of law, certainty, predictability, legality, that would ensure that any piece of legislation achieves the intended goals. And the mechanism which the courts have chosen is judicial review. Basically, judicial review is concerned with the courts scrutinizing a piece of legislation and declaring what the law is. That is essentially what it is, or declaring what the law is not, or being asked to issue orders that are appropriate. They may issue orders of compliance. They may issue orders restraining certain parties, including the executive, not to undertake anything that may be illegal. I'll give you an example about the exponential growth of judicial review, just to highlight the importance of your powers. There are many cases across the globe in our region, but because I speak to you from Port Moresby in Papua New Guinea, I thought I must just highlight a very interesting case that underscores the power of the courts insofar as issues of budgets, public finance are concerned. This is the recent case of Peter O'Neill in Papua New Guinea. It is a case of a kind. In fact, many of you will recall that 20 or 30 years ago in law schools, the thought of a court entertaining any complaint around a budget and seeking orders to nullify the decisions of the National Assembly around a budget were considered unlikely. It was judicial blasphemy to think along those terms. But as a result of the exponential growth of judicial review, this is happening. And in 2020, this happened in PNG, in the case of Peter O'Neill, where he approached the courts and asked the courts to set aside the budget that was passed by Parliament on a number of grounds that alleged breach of the law. In that case, the court entertained the complaint, and at the end of entertaining the complaint, found that Parliament was in breach of various provisions of the law and granted the remedies that were sought by the applicant. Among the wide-ranging reliefs that it gave, it declared that the Speaker's decision on the 16th of November 2020 is unconstitutional and invalid. It also declared that the sitting of Parliament on the 17th of November 2020 was unconstitutional, invalid, and ineffective. It declared particularly that the national budget passed at the sitting of Parliament on the 17th of November 2020 is unconstitutional, invalid, and ineffective. And it ordered Parliament to resit to consider these matters afresh. There are many other cases. Any student of constitutional law would say this is mind-boggling. I cite it to highlight the power in your hands, my lords, my ladies, and your worships of magisterial bench, that in your hands, you have so much power that you can actually shape the future and the welfare of the nation by ensuring compliance with the law. And of course, that is important, that there must always be enabling legislation in place to ensure that the courts can carry out their functions properly. And this SADC model law on public finance management is one such excellent piece of model law that gives SADC member states such a resource to actually learn and take certain provisions that suit their circumstances. So, Director of Proceedings, I have highlighted the importance of the courts to ensure legality, to ensure that the welfare of the people is achieved, and all this can be done by an independent judiciary that acts independently, that is impartial, and that ensures that legality is complied with, that ensures that the exercise of public power is justifiable without fear or favor. So the legal framework that is suggested by the SADC PF is very important, and member states can actually domesticate this model law as they wish. And the judges themselves, they can use it as a source of soft law in order to fill gaps in legislation, in order to justify their reasoning power. The use of soft law and international law in jurisprudence in our region is no longer controversial. The Bangalore principles have stated that the courts can resort to international law and they can resort to soft law in order to augment certain gaps in their own jurisdictions, insofar as a legislative framework that may be inadequate is concerned. I think I have reached my 15 minutes, and if you permit me, Dr. Moyo, Honorable Facilitator, I want to thank you so much for the pleasure of your company virtually and for listening to my remarks. Thank you once again. Thank you. I wish to end so far. Thank you.
Thank you very much, Justice Dingake, for the keynote address. Indeed, the courts and the judicial officers led by the Chief Justices, magistrates, and the officers that work in financial tribunals play a very vital role in making sure that there is robust interpretation of the provisions related to financial crimes. And it is therefore important that we are engaging with them, and we feel honored with your presence, sharing your knowledge, your vast knowledge and experience. Indeed, this process benefits from your presence and your leadership. We have been requested by Dr. Moyo to step in. He has been having challenges. I see, Dr. Moyo, you are muted.
I'm back.
Are you? Yeah, sure. Please proceed.
Thank you very much, and thank you, Honorable Justice, once again. I'm sure the panel here, the conferencers here, noticed the positive correlationship between the CV, the resume, and the delivery. You did not disappoint at all. Thank you very much. And I was really impressed by the fusion of the public financial management language and the legal language. That fusion can only come from wisdom. Thank you very much. With your permission, Madam SG, allow us now to show a very brief video for our participants to relax, to sit back and watch, interpret, so that as we go deeper into the engagement with the document, your battery is recharged. ICT, please, can you give us the short video? Korashe? Okay.
This is not about a campaign against multinationals just blankly. We would like to see clean businesses who come here, pay their taxes when they work with us. The idea of reporting all their profit in a small headquarters where there are only 2 or 3 people working there and overlooking the entire operation, which is 60-70% of it is happening in this continent, we would like that to stop.
Curtail abusive transfer pricing, for example, trade misinvoicing, for example. There's a lot of work that remains to be done.
We must indeed achieve the objective of stopping the bleeding, of retaining these resources on the continent, which are illicitly flowing out of the continent.
These scenes are not so dissimilar to one that happens every day across the African continent. A businessman goes into a bank and makes a transfer of funds to an offshore company. Little questions are asked and millions are funneled out of the country electronically in a matter of minutes to a territory where little or no tax is accrued. This scenario is also surprisingly legal. A senior government minister collaborates with a mineral company executive to stash money and profits earned illegally in a foreign bank. A woman gives $5,000 to a man in the hopes to get her whole family across the border illegally. This is a human trafficker. He deposits the money in an overseas bank where it is cleaned and legitimized. All these are examples of illicit financial flows, or IFFs. Money leaving the continent, being funneled into international, global, already developed capitals and depriving African national economies of vital liquidity and resources. The campaign to stem IFFs, or previously termed capital flight, is by no means a new phenomenon and has recently received a boost by the revelation of the Panama Papers, an unprecedented leak of over 11 million files detailing wealthy individuals and numerous multinationals exploiting secretive offshore tax regimes has elevated the issues of illicit flows to the forefront of the global agenda and media scrutiny. The establishment of the high-level panel represented a watershed and new strategy to combat the illicit flows.
All started on a Sunday in Malawi. We were preparing for the opening of the African Ministers of Finance, Planning and Economic Development Conference in 2010. The room was full. We were really surprised with the response. And those who attended, they said, no, this has to go to the ministerial proper the following day. And we had a 2-hour discussion on it. And African Ministers of Finance, in their wisdom, they said, no, this is a development issue that is too important for the continent. We cannot allow this continent, the poor part of the world, to subsidize the rich part.
I sometimes refer to it as being like a hydra with many heads. And a strange hydra, when you cut some heads, by the time you get to the 7th head, the first one has regrown. It's so dynamic, it keeps on changing shape and form. So we have to be resolved to the fact that we will always be chasing, finding out new ways of illicit financial flow and trying to deal with them. That's the first thing.
GFI analyzes illicit financial flows, not only out of Africa, but out of other parts of the world as well. We did a study of illicit money going out of Africa. We were asked by UNECA to come and discuss it. We did so. This is going back 5 or 6 years now. UNECA was frankly fascinated with our analysis that the commercial component of illicit financial flows is bigger than the corrupt component of illicit financial flows. Because, quite honestly, the media had been for years enjoying its criticism of Africa for the amount of corrupt money that is going out. So we came along and said, yes, corruption's a problem, but the biggest part of this is commercial.
According to GFI, these are the three clear definitions of IFF as seen before earlier: corruption, criminal, and the commercial aspect. The estimated 50 to 80 billion US dollars that the African continent loses annually in illicit flows is about double that what the continent receives in ODA, or official development assistance. Moreover, based on the methodology of the Economic Commission for Africa, abusive transfer pricing and misinvoicing, the underreporting of amounts produced and profits made are another major source of commercial illicit funds lost forever.
When we then presented our report to the African heads of state and government, they adopted the report in full, adopted the recommendations that we had made, and then decided as African heads of state and government to follow up on the implementation of what had been the recommendations, which had then been adopted as decisions of the AU summit.
There has been a confluence of forces that have really given this a boost, and also, as you know very well, the birth of this was looking for how the continent can finance itself. And one of the immediate low-hanging fruits was the issue of illicit financial flows out of Africa. So I think it's firstly therefore leadership, secondly circumstance, and thirdly the strategy brought to this by the ECA.
So it's been an exciting work, and the whole purpose is to promote African development. And how do you promote it? There has to be resources. It's resource mobilization. And in that regard, what are the obstacles to resource mobilization? And one of the obstacles is illicit financial flows from the continent.
There is really nowhere else on the continent where there is a plug-in for policy and legislative shifts that we need to make on the continent to defend our outflows, other than currently the high-level panel. And they're doing a tremendous job because they've gone from beyond the report and letting it gather dust in somebody's office, but also looking at the systemic work that needs to be done, work with regards to policy and policy shifts, both at the ministerial, Ministry of Finance level, as well as bringing in civil society and regional organizations to make the necessary policy shifts that we require. It's good work that they do.
Even before the Panama Papers, they have managed to elevate the issue of international financial flows, at least, or illicit financial flows from Africa, at least, into an international issue. It's a global challenge also. So they anticipated the Panama Papers, perhaps they will be similar in future, but already the work of the panel has already put this into the fore, has already elevated this into a global issue, a global challenge, something to carry in global action.
Illicit flows have steadily increased over the years in scale and magnitude, and fundamentally undermine our ability on the continent to achieve our sustainable development goals, impede transparency, and risk further increasing inequality and poverty. The campaign to stem IFFs is now galvanized under a wider context, incorporating an array of actors from civil society, tax and governance advocates, and government and parliamentarians.
We wanted it on the global agenda. It is now on the global agenda. So there are many people who are part of this campaign to stop the continent bleeding of these resources. So it's governments, it's civil society, it's business, it's everybody.
Our role we see as bringing the interests of citizens on the table to ensure that the design of policies that will ultimately curtail illicit financial flows and ensure domestic resource mobilization are policies that are not also at the same time leading to increased inequality and having a situation where it's already the poor that are already carrying the burden that are going to suffer out of that. And for that to happen, you need to have civil society organizations in the room to create that critical mass of actors to be able to again demand that the politicians and the governments actually fulfill their commitments, honor their commitments in terms of what they said they are planning to do to curb illicit financial flows.
Firstly, do you even know that there's IFFs? And if you do, what does that mean to you as a political party? In election campaigns, in parties that are in parliament, because we just say MPs, some come from ruling parties, some from opposition. Those that are in ruling parties, how are you influencing your own ruling party in terms of IFF? But more so, because parliamentarians get a budget for constituencies, are you taking this as an issue at constituency level, where you are saying in terms of mobilization, how do I take this message and explain it to an ordinary African? I mean, Panama Papers came. For Africa, we say they came, they are gone. For most African communities, it has meant nothing. People don't even know what that is. So we are saying at APNIFT, it is your role as an MP to take this message to that lower level, because these are the people that vote and keep governments afloat. If they are not empowered to know what is going on, they are never going to hold governments accountable.
Accountability is also in need of another key building block to fight illicit flows: capacity. Capacity building of appropriate institutions across the continent is key to improving skills and enforcing financial retention.
We begin to see that capacity challenges, or the lack of capacity, is a critical issue for combating illicit financial flows and stopping the bleeding. In particular, one area where African countries have big problem is actually implementing the legislations and the laws that they have for money laundering and for corruption and for all kinds of activities, illegal outflow of funds. And so we're working very hard to strengthen these institutions so that they can become more effective in dealing with these issues, and they become better coordinated in terms of what they do.
A clear metric on the success of tracking illicit flows is also its subsequent retrieval. Headway has now been made in a number of countries, generating repatriation of funds and the curtailment of aggressive tax avoidance regimes.
But we need even improvements to track it better. Better accounting and international accounting standards, better capacity with customs officials, better capacity in drawing agreements and other things. I mean, even just identifying or tracking will take some effort.
Uganda recently won an international court case against a British oil company, and as a result of that case, gathered $423 million in income that they would have lost did they not have a capital gains tax policy and law in Uganda. Many African countries do not have that, and because Uganda had that law, they were able to go to international arbitration, win the case, and now have that income.
The cumulative effect of strengthening financial architecture, challenging banking secrecy, and reforming common tax orthodoxy reduces outflows and critically increases income on the continent. As the fight to stem illicit flows continues, the policy and legislative shifts being implemented by the panel will inevitably need to adapt to future innovative and more clandestine methods of outflows, preempting a drive to shift not only the legal structures, but also an overall moral offensive on IFFs and their consequences.
You know for a fact that basically everybody in the world is going to disapprove. It might be legal, but if it's immoral, and people understand what that immorality means in practical terms. But secondly, I think there's much greater commitment among governments throughout the world that where legislation doesn't exist, it must be passed. Where it exists, it must be enforced. That you need all of these agreements and benchmarks, standards and all that to ensure that you have both you can have moral motivation, please act correctly, but you must also have the law on your side to say those who don't act correctly, then the law can act against them. So that you see, even the definition of what's illicit in terms of the law, as people understand the loopholes and so on, and the impact, the negative impact of these illicit flows in terms of the quality of the lives of many, many people.
Thank you, Kurashi and your team. Honorable justices, judicial officers, magistrates, learned colleagues, I think you'll agree with me that this video is very depressing. Depressing in the sense that we're informed that between 50 and $8 billion is moved out of Africa on an annual basis. That money could have been used for social and economic and cultural rights, for housing, for education, for health. But that money is moved to some offshore financial centers in some advanced countries. It's really depressing. And I'm sure you will then agree with me again that this calls for a model law in public financial management that is going to deal with the issues of cabing, stemming and combating the abuse of our resources. On that note, allow me, my learned colleagues, to call upon our learned colleague, Professor Daniel Greenberg, to take us through the key provisions that are critical for discussion at this moment. The process would be, you will make that presentation, but you'll be free to be raising questions either through chat. We have a chat, our chat platform there. You could use that. You can raise your hand. You can stop him, but we will, at the end of his presentation, provide some time for your input, for your intervention, and for your questions. Otherwise, Daniel, you have the platform.
Distinguished facilitator, Dr. Moyo, member of the Technical Working Group, distinguished Secretary General, our keynote speaker, the Honorable Justice, honorable and worshipful judges and justices of the SADC region, and if I may follow the lead of our Honorable Justice keynote speaker, I also join him in extending a particular welcome to citizenry of SADC member states joining us now, or indeed following us later through a variety of social medium forums. The model law on public financial management will work if and only if it has the engagement and ownership of the citizenry who feel that it serves their purposes. And all of us, and I make bold here to speak for all of us from the SADC Secretariat through to the honorable and worshipful judges and justices of the bench, are your servants, and welcome, therefore, your engagement in the development of the model law. If I may say to the honourable and worshipful judges and justices here assembled, as a legislative drafter of some 35 years experience, it is not unusual for me to have my handiwork scrutinized and indeed criticized by the honourable and distinguished judges and justices. It is something of a refreshing novelty, however, for them to scrutinize it before it has been enacted. So I particularly welcome your involvement here today, and I look forward to receiving your comments, unusually for me, while there is still time for me to do something about it, rather than awaiting your criticisms of the enacted law some years later. I also note particularly the remarks of the distinguished and honourable Justice, our keynote speaker today, adverting to the model law as having utility as a soft law resource for purposes of administrative law prior to its domestication and enactment. That observation of his, albeit today in a purely obiter capacity, that observation of his should strengthen the feeling of responsibility on all of us to get this model law right at this point because of its pre-domestication influence. I wish to make two comments of a preliminary nature before I take us through some of the key provisions of the model law. The first is, and honourable and worshipful justices and other distinguished delegates assembled today do not need me to remind them of this, but I draw it to our collective attention that the legislative drafting process of this model law has had to effect a balance between a number of conflicting desiderata. In this case, the draft has had to attempt to balance the needs of simplicity in order to ensure an effective citizen ownership, compliance, understanding that leads to effective implementation. But that simplicity has had to be balanced against a requirement for certainty in what is a particularly complicated technical area, as was alluded to by His Honour the distinguished and honourable Justice, our keynote speaker. So much so that he permitted himself to doubt at the beginning of his remarks whether all of this is strictly justiciable, and he concluded that it was, and indeed must be, as we had also concluded, and yet it needs to be capable of balancing that degree of technical certainty that speaks to the target audience technical professional groups, at the same time as maintaining a sufficient simplicity to be capable of being enforced and implemented. Similarly, we have tried to balance the accessibility, which goes beyond the simplicity of structure, and accessibility in using natural language so far as possible. That accessibility that again speaks to the heart of the necessary citizenry engagement, with an accuracy that again produces the correct technical result within this complicated technical context. Again, similarly, we have tried to balance a clarity in the presentation of that simple and accessible form against a flexibility that is fundamentally necessary in this substantive area. I draw honorable and worshipful delegates' attention in this respect, in particular to part 12, which deals with the crypto assets and cryptocurrency. One of the most challenging aspects of a public financial management system today, and one from which no state is able to withdraw, whether or not they have any present proposals to issue or authorize their own crypto assets. State finances will be and are already exposed to crypto assets, including cryptocurrencies, in a number of ways, whether through state-owned enterprise, whether through involvement of on-lending in government debt, asset valuation for government debt purposes. There is no way of hiding from this emerging issue, but it is an emerging issue, and emerging so fast that were we to present a clear picture of the regulatory position today, that clarity would become obsolete within weeks, never mind within years. So we have tried to balance there and elsewhere a clarity with a flexibility. In the case of part 12 on cryptocurrencies, we have attempted to effect that balance by drawing fundamental regulatory principles that we hope are enduring from the London School of Economics and Political Science Institute of Global Affairs Basic Principles for Regulating Crypto Assets, fourth draft, and building in the flexibility, a mechanism for executive flexibility to adapt to the emerging trends and developments in relation to crypto asset valuation, classification, consumer protection, cryptographic technology regulation, and other matters as the technology develops and its practice changes. And finally, we have tried to balance principle and enforceability in a way that I will allude to again in a moment. My second preliminary remark relates to contextualization and domestication, to which again the distinguished and honorable Justice, the keynote speaker, referred in his opening remarks, as did our distinguished facilitator, who, as a member of the technical working group, has been fundamentally involved in supporting the contextualization preparation within the draft itself. As to that, we have to take cognizance of the fact that each of the SADC member states has a unique constitutional and legislative arrangement in respect of public finance structures, and the model law therefore has to acknowledge the fundamental principles and acknowledge too that they will be dealt with to a different degree in different constitutions and other legislative arrangements of each SADC member state. There are footnotes throughout the draft that draw attention to particular contextualization, domestication issues, but throughout the draft, it is understood that while the model law will set a standard based on international best practice, both regionally and elsewhere, it is fundamentally necessary for the domestication process to contextualize within each jurisdiction by reference to the Constitution and other legislative arrangements. With those preliminary remarks, I now turn to draw the attention of honorable and worshipful judges and justices present and other distinguished delegates to some key features of the model law. I am now sharing my screen. would somebody from the Secretariat please confirm that my screen can now be seen by delegates?
Confirm.
Thank you. Part 2 of the model law articulates aims and objectives beginning in clause 9 with a purpose clause. I draw the attention of distinguished, honorable, and worshipful delegates to the fact that this is not merely in the preamble. This is operative law. This is a purpose clause to which the judges will have regard in accordance with the principles of administrative law when undertaking the functions already adumbrated for us by the honorable and distinguished keynote speaker in his address. Those principles are, in the purpose clause, accountability, transparency, independence, and modernity through efficient and effective process for the raising of public revenue, expenditure of revenue, accounting for receipts and expenditure, and parliamentary oversight. This is an operative provision that is intended to flavor the obligations under more specific provisions of later parts. Clause 10 requires the designation of systems for measuring the success of the executive in achieving the aims of optimization of revenue and expenditure, prevention of unauthorized expenditure, sustainability, and accountability and parliamentary oversight. Again, this is a fundamental operative provision that is designed to flavor the specific obligations later in the text. And the executive here is mandated to operate a scheme of measurable benchmarks for testing success in achieving those outcomes. In a number of places, the draft alludes, indeed refers, to the public financial management principles, which will be applied in accordance with the administrative law structure of each jurisdiction. And those principles are articulated in clause 11, transparency, accountability, and participation, including formal and meaningful opportunities for public participation, oversight, and responsibility. And finally, the public financial management principles, which are subject to an administrative law have regard duty in clause 11.2, are articulated in clause 12 as integrity, independence, impartiality, equity, professionalism, accountability, and responsiveness. Finally, in part 2, the contextualization to which I alluded is provided for expressly in clause 13. Part 3 sets out the executive authorities, including the minister, the finance secretary, the role and duties of the finance ministry under the finance secretary, the permanent civil service representative of financial management, with the general functions of the ministry being set out, and with the accounting officer being, as a matter of administrative law, the core public financial management responsible official within each departmental unit and equivalent. Part 4 deals with the public funds, including the consolidated funds and specific accounts, retention account, trading account, debt servicing account. These all being technical matters, as was alluded to before. Part 5 deals with supply and appropriation process within each jurisdiction, and the emphasis here is on the authority of Parliament and the legislature in each jurisdiction to ensure that the appropriation in aid and other supply procedures are applied lawfully and effectively. Part 6 deals with parliamentary control, underpinned by a parliamentary engagement principle encouraging Parliament in each jurisdiction to use the full range of mechanisms for overseeing and controlling. Those mechanisms are listed in a non-exhaustive list, but fundamentally here and elsewhere, the draft lays emphasis on the standing orders of each Parliament and legislative body. It is very much not for the model law to be prescriptive of the oversight and supervision mechanisms that each jurisdiction wishes to impose on itself in its own political and legal context. The Auditor General's role and independence is stressed here in clause 36, and clause 37 identifies and makes it a legal requirement for all public authorities to act in a manner that recognizes the status of the Auditor General as accountable to Parliament and independent of government. The National Audit Office is provided for similarly, and the functions of the Auditor General are set out. The Public Accounts Committee, a fundamental parliamentary resource, is explored and described in clause 44, with its relationship with the Auditor General in clause 45 and 46. The public engagement centrality is underpinned by a requirement on the Public Accounts Committee, an administrative law enforceable requirement to operate a complaints portal, and this fits with the whistleblowing protection which honourable, worshipful, distinguished judges and justices and other delegates present today will identify as being absolutely vital to the enforceability of the public financial management administrative law obligations. Without whistleblowing protection, one would struggle to provide for effective enforcement, albeit that we hope that the whistleblowing protection's existence will suffice in itself to ensure the responsibility referred to above in part 2, without hopefully ever needing to be used. Part 7 deals with the national budget process in the way that delegates would expect. The accompanying documentation to the budget documents again strengthens the oversight and also the public engagement principles, with departmental objectives being required along with a sustainable fiscal policy statement, a sustainable development goal statement, an international commitment and project statement, an equality and diversity statement to put equality and diversity realization at the heart of public financial management policy, past year and future year implication statements, multi-year budget projections, and a public debt statement. The flexibility and clarity balance to which I alluded in my preliminary observations is perhaps more noticeable in this part than in some others, with the requirement to accept virement, national adjustment budgets, in-year budget reports, delays, pre-budget expenditure, and withholding and unauthorized expenditure, all of which are inevitable features of the system, but which require still to be controlled and overseen within the envelope of public financial management, not to allow it to be diluted or undermined entirely. Part 8 deals with government borrowing, including wide classification of debt, a debt management process involving a strategy and a committee, borrowing powers, the authorization within the model law, linking to the scrutiny mechanisms of the law itself, the issue of securities, the register of securities, and the recognition of other borrowing mechanisms, including on lending, guarantees, and indemnities, all to be brought within the public debt statement, which has already been mentioned as a budget document, and within the debt schedule, which is required to be appended to the budget accompanying document. The debt ceiling provided for in the part, again, is not a prescription of a substantive nature, which would not be appropriate in a model law. again, it speaks to the mechanisms. Once that ceiling is reached, it triggers excess reports, enhanced scrutiny, and those matters are within the purview of the model law. Part 9 deals with procurement and use of public resources on a resource accounting basis, not on a cash accounting basis. So important to deal with the illicit financial flow issues that we heard discussed in the video clip a few moments ago. Similarly, the accountancy mechanisms that we will come to emphasize whole of government accounts for the same reason. But before we leave procurement, again, flexibility acknowledged by allowing the procurement regulations to give at times of specific emergency, but giving without breaking, giving without undermining the envelope within which the procurement systems require to be constrained. The public accounting principle focusing, as I say, on resource accounts within an overarching context of whole of government accounts to give a full and fair view at a global executive level. Part 11 deals with financial misconduct, misuse, and maladministration, and aimed at public officials drafted in the widest possible way. It requires an offence of public financial misconduct, and it leaves the penalties to be addressed in a way that reflects in a proportionate and effective manner the criminal and penal policy of each jurisdiction. Same for the offence of misuse of public funds, and each carry appropriate defences to ensure that these are not strict liability offences that would come to undermine their own effectiveness. Maladministration is not here cast as a separate offence. It is cast as a power for reports of the Auditor General, the Public Accounts Committee, or certain investigations or inquiries, and therefore, in accordance with the separation of powers, it does not trigger a penal response. It triggers a disqualificatory response in accordance with parliamentary powers in relation to certain public offices. Part 12 on crypto assets and cryptocurrencies I have mentioned before. And finally, I allude in part 16 to the last of the flexibility requirements, where there is a power for supplementary regulations and to issue guidance, but always subject to parliamentary oversight and scrutiny, which is provided for expressly. I hope that I have given honourable and worshipful judges and justices and other distinguished delegates present here today a brief glimpse of some of the core features of the model law most likely to be of interest to them, and I thank you for your attention.
Thank you, Daniel, for the brief. I'm sure the justices and the learned colleagues here were following, and we shall be opening the house, if I may say, for discussion. You put on the table the key issues that may trigger that discussion. Is now open. Colleagues, you can raise your hand for your input, for your question, for anything that you may have regarding the presentation that has been made. The colleagues that speak in Portuguese, French, we do have interpretation there, as you advised at the beginning of the meeting, so we can tune in there. Your hands for your contribution. whilst you are thinking, Daniel is our legal mind in the drafting of the model law. He's our legal drafter. And we thank him for the work he has been doing. This is our meeting number something. We have had several of them, and he has been there all the time. We have met Parliament, officers from Parliament. We have met officers from other sectors, and he has been there. So we thank you, Greenback, for your untiring. You have been doing sterling job. We have a hand from Madagascar. The colleague from Madagascar, you have the floor.
Oui, je vous remercie pour m'avoir donné la parole. Et premièrement, je tiens à m'excuser pour mon retard, parce que j'ai des problèmes de connexion. Dans un premier temps, j'aimerais bien vous féliciter d'abord pour avoir pu déjà proposer une telle loi type sur la gestion des finances publiques. Là, je tiens également à signaler que je fais partie d'une juridiction financière du tribunal financier de Madagascar, donc d'Antananarivo, la capitale. Et là, par rapport à nos attributions, d'abord, nous contrôlons systématiquement donc, les comptes des collectivités locales. En fait, nous avons 4 majeures attributions. Mais l'une de ces attributions, c'est le jugement donc, des comptables publics. Et j'ai également le contrôle de la gestion des ordonnateurs. Et par rapport à cela, justement, il s'agit d'une loi type auquel nous sommes amenés à discuter. Donc, à ce titre, il y a des points communs donc, qui appartiennent à tous les pays membres de la SADC. Et il y a ces points communs qui nous réunissent, mais il y a également les points spécifiques par pays. Et là, j'aimerais savoir, est-ce qu'il y a une certaine latitude, une certaine liberté donc accordée à tous les pays par rapport à ces spécificités. Pour le cas de Madagascar, justement, actuellement, la structure de la gestion des finances publiques ici présente, donc, nous appliquons le principe de la séparation des fonctions entre les ordonnateurs et des comptables. Donc, il y a des attributions bien séparées, bien spécifiques, aussi bien pour les ordonnateurs que les comptables. Le régime de la responsabilité est également différent lorsque des fautes sont constatées, lorsqu'il y a donc des fautes de gestion, ou bien lorsqu'il y a des manquements ou des irrégularités qui seraient constatées. Donc, à ce titre, j'aimerais savoir jusqu'où donc chaque pays est libre d'apporter, de garder ses spécificités. Merci.
Thank you, Madagascar. Daniel, because you don't have another hand, you can respond.
Very grateful for the question from the distinguished tribunal judge from Madagascar. The answer is not only are SADC member states permitted to do that, they are encouraged to do that, and even more than encouraged. As I mentioned before, in domestication, contextualization will be key, and it is absolutely essential that each implementing, domesticating state considers how to build the mechanisms of the model law effectively into the existing financial management structure of its own constitutional and legislative arrangements. So not only, so the answer to the honorable and distinguished delegate is a resounding yes, and indeed this will be the domestication challenge for effective implementation in each jurisdiction.
Thank you. It seems I have lost you. Are you still speaking? Daniel, are you still on the floor? Daniel, are you still on the floor?
I finished my answer. I finished my answer, Dr. Moyo.
Oh, okay.
I know it's unusual for a lawyer, but when I finished my answer, I stopped speaking.
No, that's all right. That's all right. Thank you. Any intervention from colleagues? Perhaps whilst they are thinking and they are trying to absorb the lot of stuff that you put on the table for us. There are the issues that you raised about cryptocurrencies, and here we have the legal minds. Are these issues covered? If you read that the document, are these issues covered adequately for the kind of cases that you have faced in your work? Perhaps that's I'm triggering some debate, some discussion around that provision. And this is not directed to Greenberg, it's directed to colleagues. We have provisions around the issues of cryptocurrencies, for example. And I am saying, are these provisions adequate? What's your take on them? You are not obliged to make a comment on this one. You can still make a comment on what you want to make a comment on. I'm not seeing any hands this side. Oh, yes, Malawi. Thank you. You have the floor, Malawi.
Yeah, thank you, Dr. Moyo, and thank you, Daniel, for the presentation and the model law. Mine is just, I think for now, by way of general comment. I'm particularly interested in clause 82, which is the requirement for a public debt statement. And just noting that that is something we don't have in our jurisdiction currently, that is Malawi. And it would be of interest to see how this would be received because I think public debt is one of the thorny issues, if I can put it that way. But by way of, if the model legislation was adopted, I think it would be a way, a progressive way to go for us as a nation. I'm just a little unsure at the moment as to how it would be received on the political end because of the nature of the management and servicing of public debt at the moment. I'm also interested in clause part 12, cryptocurrencies, because that is something that we don't have at the moment in our statute, on our statute book. But I think this is also a way to go because cryptocurrency is no longer something we just see from other jurisdictions. We have incidents of the Ponzi schemes happening right within the cities, and even one or two cases before the High Court. I can speak of definitely one on cryptocurrency. So these interesting provisions that we may consider in our jurisdiction, but as to how the reception would be, maybe that's a story for another day. Thank you.
Thank you, Malawi. Thank you, Mdalimanja, for that intervention. Perhaps Greenberg, what would you consider to be the punchline on the provision on date? What is the bumper sticker of our model law?
Well, I think, if I may say so, that the honourable and distinguished judge delegate from Malawi has identified that the political sensitivity around the debt management schedule and statement goes to the heart of what the model law is trying to achieve in terms of accountability and transparency. And it is, of course, transparency is not without its politically controversial aspects, but that is unashamedly what the model law is aiming to achieve. And I think in the context of today's consultative forum, we have to acknowledge that transparency and accountability can be enforced by the judiciary if they are founded in clear administrative law duties as set out in the model law. Otherwise, they are pious exhortations or they are ambitions that do not sound in actual legal duties. So the purpose of the model law, as she has identified, is to take these ambitions and turn them into clear legal duties.
Thank you. Thank you. Any further, any follow-up or any new input, question, intervention? Those that cannot make interventions now, we are very happy to receive a written input directed to our Secretary General. We have Madagascar. Like to have the second bite of the cherry. Madagascar, please. You have the floor.
Oui, merci. Concernant également la crypto-monnaie, j'aimerais également dire que ça ne fait pas encore partie de la monnaie qui a cours légal et cours forcé ici à Madagascar. Donc, ce n'est pas encore reconnu comme étant des deniers publics. Néanmoins, Madagascar maintenant a déjà fait je crois qu'il y a une avancée sur ce point, puisqu'actuellement, la législation malgache reconnaît déjà l'utilisation des documents électroniques. Et la question la remarque que j'aimerais faire également, est-ce que la loi type prévoit la justification des opérations, que ce soit des opérations de dépenses ou de recettes, puisque c'est l'un des principaux problèmes que nous rencontrons actuellement. Et on ne sait pas si avec l'utilisation également de la crypto-monnaie, si ce problème serait encore là. Donc, est-ce qu'il y a des dispositions spécifiques sur ces justifications? Puisque en tant qu'organe de contrôle, nous avons vraiment besoin de ces justifications donc, pour pouvoir mener correctement donc, le contrôle que nous effectuons. Merci.
Thank you. Over to you, Greenberg.
Well, yes, and the technical working group, as you know very well, Dr. Moyo, indeed, I think it was your intervention in particular on the technical working group that encouraged the expansion of the provisions of the model law relating to cryptocurrency, has to deal, as I said before, with a variety of different regulatory challenges in each jurisdiction. And the honorable and distinguished financial tribunal judge from Madagascar has set out the state of development in relation to Madagascar. And I suspect that each jurisdiction in SADC has a slightly different, finds themselves in a slightly different position. What I would say is that the technical regulatory approach within each jurisdiction will have to reflect, as indeed the judge said in his opening question, his first question, it will have to reflect the regulatory realities of the financial structure of each jurisdiction. What the model law can do is identify the core principles of regulation and the core processes of regulation. So we identify the constructive engagement to integrate crypto assets into existing financial arrangements, which will be necessary to a greater or lesser extent in each jurisdiction. The need for an effective form of classification with a functional classification, identifying the different financial and other regulatory regimes to which crypto assets can be subjected, the necessary consumer and investor protections, and of course the public financial management process will primarily concentrate on the investment protection, because as I mentioned before, every country's national debt and assets are already exposed to some extent to crypto asset risks and opportunities. And finally, the cryptographic technology, which again, each jurisdiction will have to observe for itself and then react in a regulatory context in an appropriate way. So no, the model law cannot be prescriptive on these matters, as indeed it seeks not to be prescriptive on any matters, but it can adumbrate the core regulatory challenges which are required to be addressed by each jurisdiction.
Thank you, Greenberg. In fact, for me, the Secretary General of SADC PF, yourself and the whole team should be congratulated in advance on the model law, particularly on this provision on cryptocurrencies, because it is going to be one of those provisions that will be heavily adopted by a number of countries in the region, looking at the future, projecting into the future. Because this is new, and the SADC PF is leading in projecting forward. I'm excited that it is one of those provisions, one of those articles that is in the model law that will be pervasively adopted throughout the region. For now, we have Obed. Obed, which country? You have the floor. Obed, you have the floor, and tell me which country. Honorable Obed.
Apologies, I'm actually one of the rapporteurs. I think I raised my hand in error.
Okay. No, you have enjoyed being addressed as Honorable Obed there. That's all right. Any other intervention? Greenberg, you know what? In the previous meetings, there was a focus mainly on specific provisions. I mean, the auditor generals that we had were focusing on their area, and each sector that we have consulted had specific focus in the model law. But with the justices, it is the whole document. They can't choose, they can't pick and choose. It's the whole document, unlike the other stakeholders that we have consulted. But in your view, which part of our model law that you think our esteemed judges, justices, magistrates, our learned colleagues should pay particular attention? I know the whole document, but is there any that you think they should pay particular attention, and you would like to ratify
that? We will be particularly grateful for observations of Honourable and Worshipful judges and justices on the provisions to which I drew particular attention in part 2, the aims and objectives for the reasons that I gave, and to the provisions to which I drew particular attention in part 11, new offences in relation to financial misconduct and misuse.
Oh, okay. I thought you would highlight that section. We have up to 1 o'clock, but we can finish our meeting by 12:30. But unless there are more interventions, but I see the colleagues have less interventions for today. Perhaps they would like to make their inputs through writing at some point. But is there any aspect of that section that you want to highlight before I invite the Secretary General, if she has got some comments here and there?
No, honestly, nothing to add to what I said in my remarks when I drew specific attention to those two parts, and to echo what you just said now, Facilitator, that if delegates are kind enough to submit written observations in relation to those parts, we will be enormously grateful and will pay very careful attention to their observations.
Okay, okay. Secretary General, Madam, any area that you would want to make a quick intervention on?
Thank you very much, Director of the programs. Let me just place on record the appreciation of the SADC Parliamentary Forum and indicate that this is work in progress. The issues that have been raised will require us to look at offshoots in the area of capacity development, in the area of dialogue in the public domain, in the area of engagement of the multiple stakeholders, for us to create a platform where knowledge can be shared, and also for us to further some of the deliberations that have been discussed today. The model law will not serve any citizen of SADC or any person unless we appreciate the content of the model law and are able to utilize it for the benefit of our day-to-day life and the economy at large. And therefore, at this point, I would like to underscore what you have already indicated, Dr. Greenberg and yourself, Dr. Moyo, that we welcome comments in writing, pfm@sadcpf.org, or the email that you've been using to communicate with the Secretariat. We'll continue to call upon you to engage with us when we are called to do so. And we hope that this is the beginning of a long journey where we look at issues as they evolve, we engage each other and begin to strengthen the interventions of members of Parliament. I thank you, Dr. Moyo. With these few words, I'd like to thank the participants and appreciate the smooth proceedings for today.
Thank you, Madam SG, and thank you all justices here present, judicial officers here present, magistrates here present, learned colleagues here present, our drafter, our legal mind. We are grateful for
I realize we have lost Dr. Moyo. IT, Dr. Moyo seems to have dropped off.
Yes, ma'am. While we're trying to facilitate this.
Okay, but I believe he was
Thank you,
basically expressing appreciation, and the meeting may be concluded accordingly.